Thank you very much for being with us. The fraud lawsuit that could cost former President of the U.S., Donald Trump, control of some of his most prized properties. It all went to trial this Monday. New York State lawyers are vowing to hold him accountable, while he denounced the whole case as politically motivated, as a scam, his word. The civil case, brought by New York Attorney General Letitia James, accuses the business mogul turned politician and his company of deceiving banks, insurers and others by habitually misstating his wealth in financial statements, basically lying about how rich he actually is.
A $500 million judgment, a ticking clock, and the federal machinery designed to dismantle a real estate empire piece by piece. Tonight, we look at the reality behind the headlines. We separate viral rumors from the cold, hard process of federal law. This is how the United States Marshals Service actually moves on a target. And this is how close they are to the front door of Trump Tower. Let's play this clip.
You've set up my third question for me, Lawrence, perfectly. Is there an issue here that Trump thinks that there are basically a set of rules for you and I and anyone else, and a different set of rules for him? Is that what this is all about, the crux of the matter?
Well, again, it does seem that, if you look at his entire business career and also his career as a politician, he plays very fast and loose with rules. And that anytime anyone tries to hold him to account, he accuses them of simply engaging in a partisan score settling or engaging in, to use his kind of favorite attack word, a witch hunt and a scam. He's already described the judge presiding over this case as a rogue judge and as deranged. And he's also attacked the Attorney General of New York State.
Tonight, we need to talk about the intersection of a massive financial penalty and the actual machinery of American law enforcement. We are looking at a story that feels like it belongs in a political thriller, but it is written in the dry, technical pages of federal procedure manuals and court orders. The most serious development we face is not just a high-dollar figure. It is the collision between a final judicial finding of fraud and the specific mandatory duties of the United States Marshals Service. For decades, the public has seen one version of the Trump brand, a gold-clad image of success and billionaire status. But a New York court has now pulled back that curtain, finding that the image was built in part on systematic financial deception. The court has ruled that Donald Trump, his company, and his top executives lied about his wealth on financial statements. This was not a minor error. The judge found it was a persistent effort to con bankers and insurers to get better deals. One of the most striking examples from the trial involved Mr. Trump's own home, his penthouse at Trump Tower. For years, financial statements valued that penthouse as if it were 30,000 square feet. The actual size was closer to 11,000 square feet. Because of these findings, a massive judgment of over $450 million was issued. And that leads us to the most urgent question of the moment. What happens when the money isn't paid? Across social media, you may have seen dramatic videos of federal marshals marching into buildings or serving seizure notices. While many of those videos are dramatized or even fictional, the legal framework they describe is real. Federal law, specifically 28 U.S.C. Section 566, states that the U.S. Marshals Service shall execute all lawful orders issued under the authority of the United States. This is not a suggestion. If a court orders the seizure of an asset to satisfy a debt, the marshals have a legal obligation to step in. We are currently in a period of high tension where the appeals process is still moving, but the threat of the nuclear option, the actual physical seizure of property, is looming on the horizon. This is not just about a wealthy developer losing a few buildings. It is about whether the rule of law applies to the most powerful people in the country. If the law says a judgment must be paid and the debtor cannot or will not pay, the machinery of the state moves to take what is owed. Tonight, we are going to look at exactly how that machinery works, how it is being tested, and what it means for the future of the American presidency. To understand where we are going, we have to understand the foundation of this case. The New York Attorney General Letitia James brought a civil lawsuit alleging that the Trump Organization habitually misstated the value of its assets. The goal of these misstatements was simple. If you tell a bank your property is worth $1 billion when it is only worth $500 million, you get better interest rates and better loan terms. After a lengthy trial, Judge Arthur Engoron ruled that this was, in fact, fraud. He initially imposed a penalty of $355 million plus interest, which brought the total to roughly $454 million. Since that ruling, interest has been piling up at a rate of over $87,000 every single day. Mr. Trump appealed this decision. In New York, filing an appeal doesn't automatically stop the state from collecting the money. To stop the collection, a defendant usually has to post a bond for the full amount. This bond acts as a guarantee that the money will be there if the appeal fails. This is where the story took a significant turn. Mr. Trump's lawyers told the court it was a practical impossibility to get a bond for the full $454 million. They reached out to over 30 bond companies and none would agree. This created a moment of legal vulnerability. If he couldn't post the bond, the Attorney General could start seizing his assets immediately. However, an appeals court stepped in and gave Mr. Trump a lifeline. They lowered the amount required for the bond to $175 million and gave him 10 days to post it. If he posts that amount, the state cannot seize his assets while the appeal continues. But here is the crucial point that often gets lost in the headlines. The appeals court did not throw out the fraud finding. They only changed the amount of the penalty that had to be secured up front. Legally, the finding that Mr. Trump engaged in persistent fraud remains on the books. The court affirmed that he, his business, and 2 of his children are liable. Now, if we reach a point where the appeals are over and the money still isn't paid, the law turns to the U.S. Marshals Service. To understand what that would look like, we have to look at the Department of Justice's own Asset Forfeiture Policy Manual. This is the rule book for how the government takes property. The Asset Forfeiture Program has a very specific mission. Its goal is to deter and dismantle criminal activity by taking away the instruments and proceeds of that activity. While the Trump case is a civil matter, the enforcement tools often overlap. According to the sources, the U.S. Marshals Service serves as the primary custodian of seized property for the government. They manage a massive array of assets, including real estate, cash, vehicles, jewelry, and even art or cryptocurrency. As of late 2023, the Marshals had nearly $6 billion worth of assets on hand. If the government moves to seize a building like Trump Tower or 40 Wall Street, they don't just show up with a moving truck. The manual explains that seizure planning is required for complex assets. This planning should begin as soon as an asset is identified for potential seizure. For a property as large as a skyscraper, the marshals have to conduct a net equity analysis. They have to calculate the estimated total amount the government would actually get from a sale. This means they have to look at all the liens, the mortgages, the unpaid taxes, and the management costs. If a building has $300 million in debt and is only worth $320 million, the government might decide it isn't worth the trouble to seize it. The marshals have to be fiscally responsible. They try to avoid liability seizures, where the cost of maintaining the property is higher than the value they would recover. For high-value properties like commercial real estate, they even have minimum thresholds. For real property, the net equity must generally be at least $30,000 or 20% of the appraised value. When we talk about seizing an iconic property like Trump Tower, we are talking about a complex asset. The DOJ manual specifically lists commercial real property and operating businesses as assets that require mandatory discussions before a seizure can happen. Why is it so complicated? Because Mr. Trump doesn't own every square inch of Trump Tower. It is a mixed-use building. There are other people who own condos there. There are commercial tenants with leases. If the government seizes the building, they have to figure out how to separate what Mr. Trump owns from what everyone else owns. They have to deal with the existing mortgages and legal filings. In a real-world scenario, the court might appoint a receiver. A receiver is a person who takes control of the assets and manages them to make sure the debt gets paid. The DOJ manual notes that the government can also use restraining orders to keep a person from selling or hiding their property before the court can take it. According to the transcript of recent legal analysis, a receiver could collect the rent from the tenants in a Trump building and use that money to pay off the fraud judgment. They could even operate the business themselves, if necessary. This would be a massive blow to the Trump brand because he would lose control over his own flagship properties. The symbolism here cannot be overstated. Trump Tower is the building that made Donald Trump famous. It is where his name is written in giant gold letters. It is the symbol of his identity as a successful businessman. If federal marshals show up to secure that building for a sale or a transfer of control, the entire mythology of the brilliant dealmaker begins to collapse. But we also have to deal with the viral content that is circulating right now. There are claims that the marshals have already begun taking control of properties. The truth is more nuanced. As of late 2025 and early 2026, many of these reports are fictional or based on hypothetical scenarios. According to fact-checking sources and legal transcripts, the case is still in the appeals process. A final enforceable judgment has not yet triggered the final step of property seizure. The process of enforcing a civil judgment is slow and bureaucratic. It involves years of legal filings, hearings, and negotiations. It is not a cinematic event where everything falls apart in a single day. However, the path to that scenario is very real. The fraud finding stands. The liability is clear. If the final judgment amount is set and Mr. Trump cannot pay it, the Attorney General has stated she is prepared to move forward. She has specifically mentioned 40 Wall Street as a property she looks at each and every day for potential collection. There is another layer to this story that goes beyond just the money. It is about the independence of the U.S. Marshals Service itself. The Marshals have a unique structure. They are a bureau of the Department of Justice, which is part of the executive branch, but their primary mission is to serve the courts. Historically, the Marshals have enforced court orders even when they were dangerous or politically difficult. They are the arm of the judiciary. But the president has the absolute right to remove any of the 94 U.S. Marshals. This creates a potential constitutional crisis. If a court orders the seizure of a president's property and that president tells the Marshals not to do it, what happens? Does the Marshal follow the law, which says they shall execute court orders? Or do they follow the president, who is their boss? Legal experts have been gaming out these scenarios. If the Marshals refuse to enforce a court order because the president tells them not to, the courts become toothless. The separation of powers breaks down. We would be in a situation where the executive branch can successfully defy the judiciary. This is why the phrase, "shall execute all lawful orders," is one of the most important sentences in federal law right now. It is the line that determines whether our constitutional checks and balances are real or just an illusion. As we move into 2026, this story is going to define the legal landscape. We have a sitting president whose business empire is under a massive financial cloud. We have a court that has already frozen many of his assets to make sure the money doesn't disappear before it can be collected. The judge in the New York case issued an emergency order to lock down Mr. Trump's major assets nationwide. This includes Trump Tower, Mar-a-Lago, and his various golf courses. While they haven't been seized yet, they are frozen. This means he can't sell them, he can't refinance them, and he can't take out new loans against them without court approval. The judge took this nuclear option because of well-founded concerns that Mr. Trump might try to hide or move his assets to avoid paying the judgment. This is an extreme legal remedy, but the court felt it was necessary because of Mr. Trump's history of using legal maneuvers to avoid financial obligations. For Mr. Trump, this may be even more painful than a criminal case. A criminal case is about prison, but this is about his money, his properties, and his name. His entire identity is wrapped up in being a successful real estate developer. Having his empire frozen and threatened with liquidation is a direct attack on that identity. Let's look closer at how the government handles these properties if they are actually taken. According to the manual, once property is forfeited, the Attorney General has the authority to dispose of it by sale or any other commercially feasible means. This is called a forfeiture sale. When the government sells a forfeited property, they are selling something they now own. The court is not involved in the sale process after the final order of forfeiture is entered. The U.S. Marshals are responsible for making sure the sale happens efficiently and at market value. However, they are not allowed to sell things like forfeited firearms to the public. Those are usually destroyed. But for real estate and luxury goods, the goal is to get as much money as possible to pay off the debt or compensate victims. There is also a process called equitable sharing. Federal law allows the government to share part of the forfeited property with the state or local police who helped with the case. However, this can only happen after all the victims have been paid in full. In the Trump case, the victim being compensated is the state of New York. The court ruled that the money saved through fraudulent loans was ill-gotten gains that belonged to the public. It is also important to address the internet rumors about stimulus checks or other payments linked to these tariffs or judgments. Fact-checking sources have clarified that no such checks are being issued. While Mr. Trump has mentioned using tariff revenue for dividend payments, no formal plan has been approved by Congress. These are often viral claims designed to generate clicks, much like the dramatized videos of the Marshals. As we watch this unfold, we have to keep our eyes on the slow, methodical process of the law. The viral videos give the impression of a fast-paced collapse, but the reality is a slow grind. There are many steps on the enforcement ladder before a building is sold at auction. First, there is the original order to pay. Then, if that isn't followed, there are motions for enforcement and court hearings. If the non-compliance is willful, the judge can issue a contempt finding. This can lead to daily fines that get bigger and bigger until the person complies. If fines don't work, the court can issue direct orders for the marshals to seize specific assets or even arrest the person in contempt. We are currently seeing the court move through the middle steps of this ladder. The assets are frozen, the interest is accruing, and the pressure is building. Every day that Mr. Trump's assets remain frozen, his business situation gets worse. He can't operate freely, and the threat of liquidation hangs over everything. If he can't secure a bond or win his appeal, he faces the prospect of watching his most iconic properties he has owned for over 50 years, being sold off to the highest bidder. This case is a landmark example of how the justice system handles a powerful defendant who tries to use politics to evade accountability. The judge in this case has used unusually blunt language. She has described Mr. Trump's legal arguments as frivolous, legally unsupported, and an affront to the integrity of the court. By using such pointed language, the court is signaling that it will not be intimidated or bullied. The judge emphasized that Mr. Trump received a full trial and had every opportunity to present a defense. The outcome, she wrote, was the natural and foreseeable result of conduct that the court had already determined to be egregious and deliberate. The court also rejected the argument that these seizures are a form of political persecution. The judge noted that Mr. Trump has been afforded every procedural protection available under the law. Framing the case as political was, in the court's view, a bad faith tactic to delay accountability. We have seen this pattern of delay, deny, and deflect from Mr. Trump before. We saw it in the classified documents case, the January 6th investigations, and the defamation cases involving E. Jean Carroll. The strategy has always been to wage a procedural war to delay enforcement as long as possible. But as legal analysts have pointed out, that playbook works better against small contractors or private litigants who can be exhausted by legal fees. It does not work as well against government prosecutors with vast resources and no incentive to back down. The hard truth for the Trump legal team is that they are running out of legal paths. They have gone to the appellate courts for emergency relief and been turned away. They have requested stays and been denied. Eventually, the law runs out of patience for recycled arguments. What remains is the plain reality. A court found him liable for fraud. A massive judgment is owed. And when a debtor cannot or will not pay, the state takes their property. That is how civil judgments function in the real world. This is the moment where Mr. Trump's persona as a billionaire businessman collides with legal reality. For decades, he used the claim of being worth billions to strike deals and build his political brand. Now, the fact that he couldn't even secure a bond for a fraction of that wealth is a market judgment on his honesty. If his properties were truly worth what he claimed for years, securing a bond would have been routine. The fact that it wasn't speaks volumes to the financial world and the courts. It confirms the court's finding that the valuations were unreliable. So as we look ahead, the reverberations of this case will be felt across the 2024 and 2026 elections. The image of federal marshals at Trump Tower is a powerful one, even if it is currently just a legal possibility rather than a daily reality. It reinforces the narrative that his empire was built on a foundation of lies. For his core supporters, this may look like an attack by the deep state. But for persuadable voters, the sight of a flagship property being seized for fraud is a concrete and difficult-to-spin visual. It suggests that no amount of political power can grant a special exemption from the consequences of one's actions. The stakes go far beyond a single judgment or a handful of buildings. This is about whether the wealthy and the politically connected are subject to the same rules as everyone else. The judge's ruling and the ongoing asset freeze are a decisive answer to that question. No one is above the law. We will continue to watch this process closely. More properties will be evaluated. More legal filings will be made. The U.S. Marshals are standing by, following a manual that was written long before this case began, to ensure that the orders of the court are executed. This is not a story of a sudden collapse, but of the methodical, unyielding power of the American legal system. It is a reminder that while you can delay accountability, it is very difficult to avoid it forever when the machinery of the law begins to move. The iconic buildings that represent Mr. Trump's success are now under legal threat. His ability to operate as a businessman has been put in a financial straitjacket, and the world is watching to see if the gold-clad doors of his empire will finally be opened by a federal marshal with a court order in hand. The bottom line is that the fraud finding stands, the penalty is mounting, and the law requires enforcement. Whether it happens today or next year, the path to seizure has been cleared, and that is a reality that no amount of social media ranting can change. Thank you for joining us for this deep dive into the mechanics of justice. We will be here to track every step of this process as it moves from the courtroom to the streets of Manhattan and beyond. Make sure you are subscribed for the latest factual updates on this unfolding story. Good night.